The other thing they have to prove, and this really helped me in my case when I did this trial, they have to prove by clear and convincing evidence there are no less restrictive alternatives, right? When I was cross-examining the social worker, I said to him, tell the judge, what less restrictive alternatives did you consider? What do you mean? Now, that right there told me that he wasn't familiar with what the law said. He was just being a social worker, loosey-goosey, and we're going to make decisions based upon our gut level and the fact that we don't like the mom. Well, that's not what the law says. So I pointed him out in the statute. I said, have you ever read this before? No. Maybe I have. I'm not sure. Well, it says that you have to consider less restrictive alternatives, and you just told us that you didn't consider any less restrictive alternatives. Now, right there, technically, I should win the case. He didn't fulfill his burden of proof under the statute. Okay? But I had to go further with this judge, and I had to propose less restrictive alternatives. Here's a less restrictive alternative that people never think of. Something called family preservation. Almost every county and state, especially in California, gets federal money to provide family preservation services. But you never hear anybody talk about that because the counties get millions of dollars from the federal government to provide services to you to keep the child in the home, no matter what you did.